Get back to our top story of the hour, and that is the petitions that have been filed against Deputy Chief Justice Philomena Mwilu and together with Supreme Court Judge Isaac Lenaola, who have found themselves in trouble after the filing of these petitions. They're accused of misconduct during the hearing of presidential petition, and in that particular petition, they are allegedly met some lawyers appearing for the petitioner, who is NASA leader Raila Odinga. So let's quickly take a look what it would take to remove a judge of the Supreme Court in light of these particular petitions. Remember, there are various petitions against all the 6 judges of the Supreme Court, all of them but Smoking Wanjala. But speaking to our reporter, Sophia Anuna, earlier on, she said that her sources tell her another petition against Justice Smoking Wanjala is on the way. So let's take a look at what the law says for you to remove a judge of a superior court. From Article 168 of our Constitution, a judge of the superior court may be removed from office only on grounds of the inability of them to perform functions in office arising from mental or physical incapacity, a breach of code of conduct prescribed for judges of the superior courts by an act of Parliament. We have bankruptcy. Bankruptcy is one of the reasons for removal of a Supreme Court judge. Incompetence or gross misconduct or misbehavior, gross misconduct, one of the reasons that are being used in the various petitions we have seen against the Supreme Court judges seeking for their removal. Well, the removal of a judge may be initiated only by the Judicial Service Commission, which is the JSC, acting on its own motion or on the petition of any person to the Judicial Service Commission. And with this, of course, we are working with the petitions, the various petitions that have been filed against the judges of the Supreme Court. A petition by a person to the Judicial Service Commission under Clause 2 shall be in writing, setting out the alleged facts constituting the grounds for the judge's removal. We've seen this happen with a petition that has been filed against the Deputy Chief Justice Philomena Mwilu, Justice Isaac Lenaola, Chief Justice himself, David Maraga, as well as Justice Njoki Ndungu and Jackton Ojwang. Well, the Judicial Service Commission shall also consider the petition, and if it is satisfied that the petition discloses grounds for the removal under Clause 1, then they will send the petition to the President, who in turn shall, within 14 days after receiving the petition, suspend the judge from office, acting in accordance with the recommendations from the Judicial Service Commission. So let's take a look at what really would happen in the case of a judge who is not the Chief Justice. Of course, the President will suspend them first, then appoint a tribunal that will consist of a chairperson, 3 other members from among persons who hold or have held office as a judge of the Superior Court, or who have qualified to be appointed as such, but who in either case have not been members of the Judicial Service Commission at any time within the immediately preceding 3 years. So some of the members who will be part of the tribunal should not have been members of the Judicial Service Commission in the immediately preceding years, preceding 3 years. We'll also have one advocate of 15 years standing as part of that particular tribunal that will be formed by the President if the JSC gives that particular petition a green light, and then 2 other people with experience in public affairs, and this might also include the Chief Public Affairs Officer in the country. Now, despite Article 164, the remuneration and benefits payable to a judge who is suspended from office shall be adjusted to 1.5 until such time when the judge is removed or reinstated in office. This is something that should be pointed out. So a judge who is aggrieved by a decision of the tribunal, once the tribunal has undertaken their investigations and whatnot, if a judge is aggrieved by the decision that would have been taken by that particular tribunal, then they may appeal against the decision to the Supreme Court within 10 days after the tribunal makes its recommendations, and then the President shall act in accordance with the recommendations made by the tribunal on the later of the expiry of the time or the completion of the rights of appeal in any proceedings allowed for under Clause 8. So this is some of the that is really the process that will be undertaken if at all these petitions against some of the Supreme Court judges will be given a green light by the Judicial Service Commission, whereby they will be suspended, and then the tribunal will be formed by the president, who will in turn, the tribunal will conduct their own investigations and decide whether they will be reinstating the judge or seeking for their removal in office. We'll also be later on taking a look at some of the judges who are under investigation with the Judicial Service Commission, some who have faced tribunals, some who have been removed or whatnot. But before